Supreme Court has put into abeyance parts of the sedition law. The apex court has asked the centre and states to refrain from filing cases under this section till the government re-examines it. The court has given the centre till July for re-examination. The Supreme Court has also mentioned that those already booked can now approach other courts for relief, and that's what has effectively been put into abeyance. All pending appeals, cases, all of that now will be stayed. According to reports, over 800 cases of sedition have been filed against 13,000 Indians in the period between 2010 to 2021. Meanwhile, the case also took a political turn, with the opposition calling it a victory for democracy. BJP too says that the Supreme Court has essentially echoed what the Solicitor General has said in court. First, let's listen in to what Law Minister Kiran Rijiju had to say.
We have made our position very clear, and we also informed the Honourable Court about the intention of the Honourable Prime Minister. Beyond that, if anything else have happened, I don't know. But one thing I must say is that we respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other, and also to practice our respect in letter and spirit.
Today, going into a huddle mid-hearing, after hearing the position of the government, which said that as far as directives go, it will perhaps consider passing a directive to all states that till and unless satisfaction of superintendent level police officer has been obtained, section 124A of the IPC will not be invoked. After the mid-session huddle, the bench led by Honorable Chief Justice of India had no hesitation in staying the operation of this sticky provision of sedition law in the interim, while the government has given an assurance that it will reconsider, re-evaluate the sticky provisions. But in the interim, the Supreme Court has said that it hopes that state governments and central government will desist from slapping this particular penal provision and also registering any fresh FIRs with this section. The Supreme Court also noted as to how it has taken into account the submissions made by the Attorney General on an earlier occasion, where he conceded that there have been some instances of misuse, and he had also urged for the Supreme Court to pass some guidelines. It was only yesterday that the top court had sought certain responses from the government to assuage its own concerns, after the government, in a twist, had informed the Supreme Court that the Prime Minister himself is very keen to do away with certain colonial-era laws.
A 152-year-old law, the law of sedition under section 124A of the Indian Penal Code, has been held in abeyance by the Supreme Court. It's a big day for the courts, for justice and for democracy. This is one of those laws that has been misused routinely by governments through the many decades, and was actually a colonial law used by the British to quell the voices of freedom fighters. Now, what are the implications of what the Supreme Court has said? Will we now see a drop in such cases? Because the Supreme Court has urged the centre and state governments to not file any fresh cases of sedition till a final call is taken by the lawmakers on how to rework the provisions of the law. To speak more on this, I'm joined now by Mahua Moitra. She's a Member of Parliament from the TMC and one of the petitioners in the case. Ms. Moitra, thank you so much for speaking with us today on what is truly a momentous day. Just your first response to the entire fight, the legal fight to knock down sedition. Do you think that a broader consensus is now growing that agrees this is a completely redundant law?
Yeah, thank you, Tamanna. Yes, it is. I have to see, today is not just a historic day. It's not just a day for you or me. It is a day, it's a historic day for, I would say, constitutional democracy, because like you said, this is a law from 1870. It was designed by the British to subjugate Indians. It was never designed for an elected Indian government to throttle the voices of its own citizens. It is actually shameful that in 152 years that we haven't done anything about it, especially since independence. The last time this ever came up in court was in 1962, which again was almost 60 years ago. So 1962, Kedarnath Singh versus State of Bihar, a 5-judge bench of the Supreme Court looked at it. And what they said was they upheld the constitutional validity of the law. But while doing so, they made it very clear that the test of imminent lawless action would apply, which meant that anybody who was charged under this law had to, through incitement to violence, subvert the government. It had to be something immediately. It can't be that mere criticism of the government or protesting or resisting or criticism via constitutional methods cannot be termed sedition. So when the government today is saying that, listen, don't throw it away, just put restrictions, what they're trying to do is actually keep status quo, because the 1962 already did that. And we have seen since in the last 5 to 7 years, especially since this government has been in power, the rampant misuse of this law. Nobody has suffered it more than the media, I would say. If you look at Munawar Faruqi, he was a comedian. He was arrested before he cracked a joke. If you look at Siddiq Kappan, he was on the way to Hathras. He hadn't yet written the report. He was picked up. If you look at Rajdeep Sardesai, you look at Mrinal Pandey, you look at all the cases. These are all cases that fall within the constitutional right to dissent, and yet have been picked up on sedition. So it was high time that this was brought before the Supreme Court, and I'm very glad to be one of the petitioners to be doing it. I'm not the only petitioner, the Editors Guild of India, there were other petitioners as well. I have to thank my lawyer, Gopal Shankar Narayanan, who was lucky enough to be heard and who put up a very spirited fight. What did we have? We have this government today coming out and saying that, oh, by the way, the Prime Minister in an epiphany has seen the light, and the Prime Minister insists that there's no place for that law and we will reconsider it. Merits 2 questions. Number 1, Prime Minister's been Prime Minister for 8 years. Strange that the light didn't strike him earlier, but giving him the benefit of the doubt, I'm glad better senses prevailed.
Yes.
Why is the government coming in and saying that you will reconsider the law? The government cannot place on affidavit what Parliament will do. You can't second guess Parliament. The government cannot place on affidavit, number 1. The second thing is, if you revoke the law, use the word revoke. Why are you using the word reconsider? Because what they will do, if I know anything about this government, is to bring it to Parliament with an amendment. They will bring in an amendment, and that amendment will be exactly like something they put in court today via the SG, which is let an officer, police officer of the rank of a superintendent of police come in and decide. So they will leave it again to subjective authority.
Sure,
that's where the court stepped in.
So just on that point, and as a lawmaker yourself, and as you mentioned, this has been in court since 1962. It has been a weapon of choice of successive governments. I'm not taking away from the point that you're trying to make on its rampant use in the last few years, etc., and that political point. But the fact is, it's been a weapon of choice of successive governments. No political party or governments want to let go of this stick, so to speak. Now, one of the reasons being given is that, do you have enough of a legal arsenal to make sure that disaffection is not spread against the country, that the interests of India are not harmed? As a lawmaker, do you see any merit in that argument, that there could be a use for some sections of the law?
There is absolutely no merit in this argument. The Supreme Court has gone on record to say that you cannot hide under the fig leaf of national security for every single thing. This government, whether it is spying on us, whether it's Pegasus, whether it's seeing our data, whether it's spying on our phones, whether it's locking up people, whether it's UAPA, where you have the right to designate individuals as terrorists, they put everything under national security. And, sometimes I wonder whether they couldn't have a law saying that if the sun shines, we can see, and that's against national security, we should be able to do things in the dark. So let's put that aside. This law has absolutely no place in civilized society, has absolutely no place. What the Supreme Court has said very smartly, and my written submission via my lawyer's written submission was this, that let the government go and reconsider the law. They're going to take years to do it, months, years, whatever it is. The government has put no timeline. In the meantime, please stop registering FIRs under Section 124A, and all the people, there are 800 odd cases, 13,000 people jailed. That's what Mr. Sybil said in court. Please allow these people the right of bail immediately. So the court in its wisdom has said that no new fresh FIR should be done. The court will keep in abeyance, high courts, Supreme Court will keep in abeyance all sedition cases, and state police, central government agencies will not go into this at all till a further consideration of the law is. So Supreme Court is very clear. They have said that this is not some open-ended tool in the hands of the government. Either you reconsider it, and reconsider in the eyes of the Supreme Court is going to mean revoke. It's not going to mean an amendment. Either you do it or else we hear it. So that's the good news here.
From the point of view of what does it effectively mean for the people, and you've talked about this in the prism of freedom of speech and freedom of expression, do you think it is safe to say, or can people now believe that they have more of a right than earlier to say what's on their mind? Has this made a material change? Can we be sure of its implementation at the level of state governments, of lower courts as well?
Look, this is the process of lawmaking, of something like this. It's not overnight, as you know, but it is a very, very strong step in the right direction to creating an ecosystem in which the fundamental duties, the fundamental rights of citizens are protected. So Article 21, Article 19, Article 14, these are all protections that this law, that are given against this law. Now, what's happened is, if you see Puttaswamy, the right to privacy, when we had a 7-judge bench come out with Puttaswamy, that has had very wide-ranging implications. Now, when you have laws like the UAPA which come in, and you have sedition, very rarely is sedition applied alone. It is usually applied with X or Y or Z. So obviously the argument is going to be that, given that a person is picked up on UAPA and he's been slapped under charges of sedition, yes, we can remove sedition, but UAPA still stands. But please understand that this has to be done one sort of, undemocratic pillar at a time. And this is a very fundamental pillar that has been stated today. That it is no longer available, as 124A is not just available for any sort of police station to say thok do, thok do, thok do. It's not happening. And that's a very vital tool.
Another aspect of the entire debate during this court case and even after, from what the law minister has said today, is the role of the judiciary versus the executive versus lawmakers, and a Lakshman Rekha which is being talked about. At the end of the day, laws are made by elected representatives. But more and more, we have fallen back on the courts to decide the direction of where things go, or where things head. What is your view on this as a lawmaker?
Look, I'm a lawmaker, and I can tell you this. I can tell you this with absolute conviction: is that lawmaking has been reduced to a farce in India. It has been reduced to a farce, and you're a journalist. You cover this. We have journalists sitting in the Lok Sabha every day, in the Rajya Sabha, and they see how Parliament has become a rubber stamp. And when any party, especially now the BJP, has a brute majority in the Lok Sabha, it has more than 100 seats in the Rajya Sabha, so it can get anything through. There is not even debate on bills. There is not even debate. Now, the old thing is that the government proposes, the opposition opposes. Even those old things have been thrown out the window. So the government ramrods everything. There's no provision for dissent. There's no provision for even debate for most of these things. So in which case, where is the scope for a thoughtful, reasoned debate on issues like this? It isn't. So what are you left with? You are left with no recourse but to go to the courts. So it's not a question of Lakshman Rekha, and I like Kiran Rijiju on a personal level, but I feel bad for him that he's a fundamental believer in democracy, and for him to have to come and parrot his master's voice is a sad day. But that's what.
Ma'am, but just to take that further, the fact is that democratically elected representatives are supposed to have the right to decide on laws. And no matter what the composition is, this is a democratically elected parliament right now.
Yes.
So,
so what do you think happened in 370?
So are you worried that those lines are being blurred?
It's not worried. How can you even ask this question? Can you please just go back into the Lok Sabha archives, just watch the debates to see how many of the most important laws have been even debated? Let us understand what has been done. And if you come in today and you come in with sedition, the government, it says reconsider. What is to stop this government from coming in with an amendment? Reconsider in the government's lingo doesn't mean revocation. If they meant what they said, if the Prime Minister's money was put where his mouth is, the Solicitor General would have said, we will revoke the law, period. Matter ended. They said reconsider. They're reconsidering the entire CRPC. So, if they wanted, what is stopping them from coming in with an amendment and putting in all sorts of silly amendments like an officer of the rank of an SP or X or Y, or there'll be a committee in every district to examine all of this. And then we go back to square one. So when we do not have access to these remedies, it is very important that the courts step in, because fundamentally the Supreme Court of India is the last guarantee to us as citizens. We are lawmakers second, we are citizens first. Please understand this.
Yeah.
And to me as a citizen, it is my fundamental right to approach the court to make sure that my fundamental rights are ensured. And under Article 14, 19 and 21, the law of sedition is against all of those rights.
Okay. Last point on this, ma'am, and you talked about using the law to quell voices or political dissent or anyone saying basically what the government of the day doesn't want to hear. What do you have to say on the trend that we're seeing, where if this is the malaise, it's been spreading across party lines to states which are also ruled by the opposition? It's a formula that everyone has picked up on. Does that worry you?
So when you have something as ridiculous in this on the statute books, it is tempting for anyone in power to misuse it, which is exactly why we are saying that remove it. Which is exactly our point. If it does not exist, if something is bad in law and it exists and it is removed, then nobody's under the temptation to use it. It's as simple as that. It's not a question of X or Y or Z. If it is removed, if you cannot file if you cannot file an FIR under 124A, then I can't file it, you can't file it, the Congress can't file it, the BJP can't file it. Matter over. That's exactly what we are saying. Why are you leaving it to subjective considerations and trying to prove which party is better than the other and which is more for civil liberties than the other? I'm not into an argument of who's being tarred with the same brush. The argument is this law has no place in today's India. Let's do away with it so nobody's under the temptation to use it. Plain and simple.
All right. Well, in any case, no matter what the argument, the fact is that it's a historic day for democracy, for Indian law, and for the courts. Thank you so much for speaking with us.
Thanks.